name is Ken Krager, and I'm with QX Financial, and I want to welcome you to our first in a series of webinars dealing with financial and estate planning for families who have family members with special needs. And I have a special guest, my daughter Addie. Addie, where do you go to school?
Murrayfield High School.
Right, and Addie is all dressed up. You can see she bought her own dress and she went and had her makeup done and her hair. And where are you going, Addie?
We're going, me and Parker and Ellie and Joseph to Olive Garden. So we're going to go prom.
And where? Oh, you're going to go to the prom, huh? You're going to go to senior prom because you're senior in high school, huh?
Yes.
So Addie is the reason that we're here. People like Addie, your loved ones like Addie who have special needs, and estate planning, financial planning for these special situations can be very, very complex. And there's a lot of things that you have to worry about and think about. And one of the things that we want to make sure is that Addie doesn't become a ward of the state, that she lives a long and meaningful life and happy, and you get to go do fun things, huh?
Yes.
Where do you want to go?
May I go?
Yeah. Where do you want to go on a trip?
Cebu City.
Cebu City, Philippines. But
yeah,
but one of the things is Addie can't accumulate assets. If she gets more than $2,000 in assets, then that can be taken by the state, or it can disqualify her from benefits. And so these are the types of things that we need to think about so that Addie can do the things that she wants.
Yes.
And so, think about, we don't want, we're almost done. We don't want our estate to go through probate. We don't want anything to interfere with Addie being able to do the things that she wants. And so we want to make sure everything is planned ahead of time. We want to minimize legal activity. We want to make sure that people and our assets and things are in place to take care of her, right?
Yes.
Yeah. What?
What is my favorite color?
Your favorite color?
Yeah.
What? Blue?
No.
Red.
Yes, red.
Red.
Yeah.
Okay, so long-term care. We have to take care of my wife and myself, and we want to retire. So our assets have to be able to take care of us and Addie. We're almost done, okay?
Doctor, you say, what is your musical?
What's your favorite musical?
The Phantom of the Opera.
Addie's just like everybody else. She has lots of favorite things. And we want to make sure that we don't disqualify Addie from benefits that she's going to need. We need to talk about things like Social Security, SSI, benefits, Medicare, those types of things. We need to talk about estate planning. We need to talk about investments and different kinds of investment tools, right? So welcome, listen, ask questions, contact us if you have some questions. And now I want to introduce Janko Castro, who is the founder and CEO of QX Financial, and he will moderate and MC these webinars and introduce the other speakers and so forth. And so have a good time, think, listen, get educated. Janko, take over. Thank you very much. Say bye, Ad. All right, take care.
Hello, everyone. Like my good friend Ken said, my name is Janko Castro, CEO and founder of QX Financial. And I want to thank you all for being here today in this special needs seminar. You really have a treat today. You're going to have two incredible people talking to you about all the different options, or some of the different options you have from the legal perspective as to how to set up your affairs to take care of those that you love, right? Those in special needs. So first we're going to have Lisa. Lisa is a current attorney at law at Morris Hall, and actually she's been involved in estate planning and special needs planning for a long time. Actually, even before 2014, she has a tremendous experience as a paralegal, even before she became an attorney. And also she worked on the estate plan division at the law firm. She's actually going to tell you a little bit about her extended family. She has experience working with families with special needs. So I think she's going to do a fantastic job telling you guys about your options. In addition to Lisa, we're going to have Mr. Phil Chakilian, also a fantastic attorney. Phil got his BA in criminal justice at California State University, Fullerton, I'm sorry. And then he went on to get his degree, his JD at Whittier Law School. He has his own personal practice since 2012. So again, he has a tremendous amount of experience and he's gonna share some of that with you. So before we get started, I just wanna get some housekeeping items out of the way. If you have any questions as the speakers are going through the information, please do me a favor and go ahead and type the questions in the QA window. So you should see on your monitor, on your phone, depending on what device you're using to be in the meeting, you're going to have an option there to put questions. So please go ahead and type the questions there. And then at the end of the webinar, we're going to open for questions and I will be asking the questions to Phil and to Lisa. Also, everybody's muted, so we won't have any interruptions, and that's already been done. And last thing is at the end of the event, we're going to have a survey that we're going to ask you to complete. Your feedback will be greatly appreciated. If you want to get a hold of us or set up a time to speak with us individually, please go ahead and do that through the survey that you will get after the webinar. So without taking any more of your time, we appreciate taking a little bit of your night to be here with us. And here is Lisa. Thank you.
Hello, thank you everyone for joining us this evening. It's a pleasure to be able to speak to you all. I just wanted to give you guys a little bit of background information. I see several new names who are registered for the panelists or for the attendees today. So just want to give a brief background on Morris Hall. We are a law firm that practices exclusively in estate planning. We're a charter member of the American Academy of Estate Planning Attorneys. And we have 8 licensed attorneys who facilitate special needs trusts, estate planning documents throughout Arizona and New Mexico. Just a little bit about me. I went to school in Arizona. I got my bachelor's degree from Arizona State and my law degree from school in Phoenix. I'm also admitted to practice law in both Arizona and New Mexico, but these are really the boring details. What's really important to me and what's also important to you is your family, what makes you you and why you want to take the steps necessary to protect your estate plan. So I'm privileged to be a part of a blended family. I've got 2 siblings from my mom and then 3 siblings on my dad's side. I've got my 5 dogs and I'm recently married as well. And on my dad's side, my youngest brother is special needs. He's got a mitochondrial syndrome, which very closely represents, it's very similar to muscular dystrophy. So while he may have his mental ability to be able to kind of take care of things right now, that may not always be the case. And then it surely won't be the case in the future when we're talking about his disability from a physical aspect. The reason that I share this with you is because this is what's important to me. Protecting my family and the things that I'm passionate about is why I do what I do. And I want to share that with you guys. So let's talk a little bit about the different types of special needs trusts. There's a first party special needs trust, a pooled special needs trust, and a third party special needs trust. And as part of my presentation, I'm going to focus primarily on third-party special needs trusts. And later on this evening, I will introduce Phil, who will talk more in detail about first-party special needs trusts and some of the differences between the first party and the third party. People who receive SSI, Medicaid, and other state benefits have limitations in the amount of assets that they can own. Special needs trusts are an exception to the rule that normally apply to a trust. Normally, a trust is considered an available asset when somebody applies for a means-based public assistance program, such as SSI or Medicaid. In Arizona, these programs are called ALTEX or Access. However, a properly drafted and administered special needs trust will not be counted as an available resource, and the trust disbursements will generally not be counted as income under the rules that apply to SSI and Medicaid. However, one thing to keep in mind is that not every trust is created the same, and each and every trust has a different purpose. And that's why it's very important to talk to an estate planning professional when creating these trusts to make sure that they're uniquely tailored to your specific needs. Everything's all about balancing act. If you have a loved one with a physical or a mental disability, health issues are just one of many concerns. You likely have concerns about your loved one's ability to earn and supplement income, living in a safe and accessible environment, obtaining extra help when needed, qualifying for health benefits, and increasing the personal independence. And none of these concerns live in a silo. They all overlap and work with each other. There's some concerns that may take priority at certain times, and then there's other priorities that may take, or other concerns that may take priority in other times. And so it's a very tricky balancing act. And we want to make sure that we're here with you every step of the way to make sure that all of your concerns are addressed as appropriate to your individual circumstance. Also want to know, we want to be your best advocate and want to be able to provide for you and for your loved ones when you're no longer able to. So what is a third-party special needs trust? A lot of the questions that may come up today is, who will take care of your loved ones with special needs when you are not able to? Have you thought about leaving your assets to your special needs loved one without affecting their means-based public benefits? Or what if they're unable to handle their financial affairs themselves at all? If no action is taken, it's likely the child who will inherit money will be in the form of an outright distribution. And what this means is that the distribution that you've left to them will be treated as a gift and an available resource, which may eliminate or potentially negatively impact your child or loved one's eligibility for means-based public benefits. And this may not, in fact, benefit them at all or help improve the quality of life that they're receiving. I've even seen some parents go as far as to disinherit their special needs child altogether because they're under the misconception that if they leave them anything, then they'll be disqualified and they will leave the entire estate to either other siblings or family members with the hopes that that person will take care of the child. And usually this really causes a lot of conflict, and it does not provide any guarantee that your child or loved one will be provided for. So what's the better alternative? One alternative is to establish a third-party special needs trust. Sometimes these are also called supplemental care trusts as a part of your estate plan. A properly drafted and administered trust is an excellent way for families and individuals to plan ahead. And planning ahead is the key component to a third-party special needs trust. It ensures that public benefits will continue for the lifetime of the person with the disability, and it creates legal options for purchasing and supplementing support and comfort. In addition, there's no payback requirements to Medicaid upon the death of a beneficiary. Using a third-party special needs trust provides you and your family with the financial peace of mind, knowing that your special needs loved one will be provided for in the event of your demise. So just to kind of quickly explain how a third-party special needs trust works, I'm going to use the example here of our couple, Bill and Mary. Bill and Mary would be referred to here as the trustors. They're the ones who create the trust. They put their assets into the trust during their lifetime. They are the beneficiaries of the trust. And while they're both alive and well, they're also the beneficiaries. So they are the creators, the managers, and the beneficiaries. So nothing changes. They continue to manage their assets for their family and their benefit, how they see fit. But as opposed to Bill and Mary owning these assets in their individual name, their trust owns their assets. And if properly drafted upon Bill and Mary's death, when they both pass away, they will still continue to be the trustors. It's their money that they put into the trust, but their successor trustees that they've nominated in the trust will be the managers of the trust. And with a properly drafted trust, you'll create a third-party special needs trust where the trustee manages the assets inside of the trust for the benefit of the beneficiary. And the reason that this is really important is because had Bill and Mary left everything outright or didn't designate or plan ahead, their special needs beneficiary would potentially be negatively impacted by receiving such a large inheritance, which would be treated as a gift. While this scenario allows Bill and Mary to put everything into a trust and create a special carve out for their special needs loved one that allows them to supplement the care without disqualifying them from any potential state or other public benefits that they will receive. Also, as part of the estate plan, I highly recommend that you designate a legal guardian for your incapacitated adult child. And this is done through your last will and testament. If you're unable to provide for the care and comfort of your special needs loved one or disabled child, who's going to take care of them? Who's going to, be the person to physically take care of them, and then also to make healthcare decisions for them? You need to make sure you nominate the person that you would want to step into your shoes, whether you guys became incapacitated or ultimately, if you were to unfortunately pass away, want to make sure that our special needs loved ones are taken care of. So this is a brief summary of a special needs trust and a third-party special needs trust. I'd like to turn it over now to Phil, who's going to talk about first-party special needs trust and the differences between first-party and third-party.
Hey guys, thank you for joining us tonight. Lisa, thank you. That was amazing. I hope you guys all paid close attention to that, because that third-party special needs trust is really important for those of you who are not disabled but have somebody that you love that is. What I'm going to talk about is the opposite situation. If you are disabled and you need to take care of yourself, it's called the first-party special needs trust. So let me go ahead and share my screen with you. Okay, Lisa, can you see my screen with the slides?
Yep, I can see it.
Perfect. Okay. So my name is Phil Shakurlian. I am one of the founding attorneys of Bauer and Shakurlian Law. We deal with anything that has to do with death or wealth. So that includes anything such as estate planning, tax planning, business formation, mergers and acquisition, probate, asset protection, trust administration, contract formation and review, anything along those lines. I guess I'm lucky in the sense that some of the things I deal with are taxes and death, and they're the only two guaranteed things in life. So I guess I have a stable business model. Let me talk a little bit about myself, if I can figure out how to switch the slides. There we go. So I believe Janko talked a little bit about this, so I won't go too far in depth here. We talked about all that. I guess, one of the things that drives me is I'm a huge sports fan. So I work hard all day long so that I can go watch sports at night. I love my California Angels, now known as the Los Angeles Angels of Anaheim, which is a garbage name. And the Mighty Ducks, used to be called the Mighty Ducks, now the Anaheim Ducks in hockey. They both are pretty close to my house, so you can regularly catch me there. Fun fact, I was recently married, actually last Friday, up in Lake Tahoe in Incline Village on the beach. So we got one of the photos from the wedding here. My puppies as well, Bailey and Baxter, they actually just passed away in the last couple months, but I will be getting a new puppy tomorrow, so I'm really excited about that. And then there's some pictures from different events that I've been to. So let's talk about the important part of this presentation, and that is the first-party special needs trust. You may ask yourself, well, why would I need a first-party special needs trust? Well, once again, this is if you are the one that needs to protect your assets and protect your public benefits, you're the one that needs to set this up. So what I'm talking about is things like if you receive Medicaid, which I believe it's called in most states, or in my home state of California, they call it Medi-Cal, and that's where the government subsidizes your health care for those that can't afford it. Also something called Section 8 housing, where the government subsidizes your housing costs, state and federal disability, or even welfare. If you are expecting an inheritance for someone and they did not set up a third-party special needs trust, then you would also need to set up a first-party special needs trust for yourself. Um, and by putting the assets into that special needs trust, you can have this backup funding source and still qualify for government support rather than having to give up your government support or your inheritance or your settlements or whatever. So it's a win-win situation. Um, so now you know why you need a special needs trust, but let's talk about, what are some of the rules and what makes it a special needs trust. Um, in the state of California, or actually no, federal government, before December 13th, 2016, there was no first party special needs trust that could be created by the beneficiary, which is the person that has the need. Prior to that, that first party special needs trust had to be set up by the beneficiary's parent, grandparent, legal guardian, or even a court. Luckily, that law has changed, and that's no longer the case. And now you could set one up for yourself. I did note that was a federal law, and the way that our Constitution and justice system work is that if a federal law affords you a right, then that right has to pass down to the states. So the states have to abide by that as well. And so no matter what state you're in, you can create your own first party special needs trust. In most cases, the trust assets can only be used for the benefit of the beneficiary, which is the person that set up the trust. You can't use the funds for anything that would disqualify you from your government benefits, such as cash gifts from the trust to yourself. That's the same thing that you would get with a third-party special needs trust as well. If either first or third-party special needs trust is created properly and it adheres to the strict government rules, then you can use the assets that are in that trust for a whole wide variety of things, such as medical, dental care, prescription medication, and that includes like cosmetic surgery and non-necessary procedures, psychological support and companions, housing, in-home care, wheelchairs, mechanical beds, your utilities, including like telephone and television, recreation, vacations, transportation, dietary needs, hair and nail care, funeral expenses, rehabilitation. There's a whole list of things that you can use it for. So it's not limiting you because it's in a trust. So I guess you want to know how you would set one up then. Well, I know Lisa mentioned this already, but it's really important to say this again. It must be set up well before any unexpected inheritance or windfalls. So the sooner the better. If you receive an inheritance or a settlement or something and you don't have this trust set up, you've got problems. The inheritance or settlement or whatever have to be directed directly to the trust and never to you as an individual. I have a lot of my clients, they tell me, hey, I'm doing a trust and I want to disinherit so-and-so because I know that so-and-so is on government benefits and I know that they can't have more than $2,000 in their account. So if I leave something to them in my trust, then it's going to disqualify them from their benefits. So I'm not going to leave them anything. Well, that's terrible. If instead it's left to you and you have a special needs trust, or you do a third party special needs trust like Lisa spoke of, then you can inherit and keep your benefits. And once again, you get the best of both worlds. So you really should do your own special needs trust and let your family know that, and then they'll be much more likely to include you in your inheritance. Now, once you've made the decision that you want to set up a special needs trust, it's really important to seek out an experienced attorney who's set up these types of trusts before. Basic estate planning attorneys typically don't have that experience, and paralegals definitely don't have the skill or experience necessary. You need to, do your due diligence and find that attorney that has the experience and has done them before. I know Morrison Hall has done many of them. My firm has done many of them. And if you live in a state other than California, Arizona, or New Mexico, feel free to give Lisa or myself a call, and we'd be happy to refer you to an attorney that we do know in your state. Then once once a beneficiary does come to me, then like Lisa mentioned, every client is different and every situation is unique. So what I typically do is I take some time to sit down and get to know the client. Maybe one appointment, maybe two appointments, maybe a couple hours. I just need to know who you are as a beneficiary and what your goals are so that I can recommend the best plan for you. Once I've done that, then I'm going to ask you one of the toughest questions that you've ever had to answer is, who do you trust with all your money? Because that person is going to be the trustee of the trust, and it will be completely up to them whether or not you can access the money. If you want a car or you want food or you want housing, it doesn't matter what, they have the final say in whether or not you get that. So you really have to trust who you're using. And then after I've asked that tough question, I ask an even tougher question and say, well, if something happens to that trustee, who do you trust as a backup, or maybe another backup, a third backup? And so those are some of the tough questions that you need to think of and when setting up the trust. So let me talk to you about the differences, some other differences between first and third party special needs trusts. So the most obvious is in the name itself. A first party special needs trust is funded by the beneficiary, and a third party is funded by somebody else for the benefit of the beneficiary. A third party protects you, whereas a third party protects somebody else. A third party special needs trust also only protects assets that are transferred into the trust by the person who created the third party special needs trust and nothing else. So if my dad created a special needs trust for me and I won a lawsuit and had some money coming to me, I couldn't put that money in the special needs trust that my dad set up for me. I would have had to have my own first party special needs trust set up before the award by the court to make sure that that money is protected and doesn't disqualify me from public benefits. A first party special needs trust will protect your assets from things such as inheritance, life insurance, civil, divorce court settlements, any other insurance payouts, auto accident, things like that, retirement plan payouts, supplemental security income, social security disability insurance, any monetary payment that would make you disqualified for public benefits. Here in California, as Ken had mentioned earlier, one of the benchmarks is actually $2,000 in your account. And for a lot of benefits, if you have more than $2,000 in your account, then you get disqualified. So putting these assets into the special needs trust rather than your account will help keep you qualified for those benefits. Another difference is that, like I said, Medicaid is what it's called in most states. In my state of California, it's called Medi-Cal, but that a third-party special needs trust does not allow Medi-Cal and Medicaid to claim reimbursement against the beneficiary's death. So if my dad sets that trust up for me and I end up dying before he does, he in that trust says what happens to those assets when I die, and Medi-Cal has no right to that because I have no right to say where those assets go. Most first party special needs trusts don't have that protection, so there's a downside to that. And what a first party special needs trust has to say in most states is it has to have specific language saying that any medical assistance paid out on the beneficiary's behalf will be paid back to the state before any heirs inherit the assets. Well, luckily, there's not too many great laws in California. Most of them are high taxed and where the government is trying to take money for you, but they have given a lot of benefit to special needs individuals. And they passed a law on January 1st of 2017 that allows for any assets in any type of trust, whether it's a revocable living trust, a special needs trust, any other type of irrevocable trust, as long as the assets are in a trust at the time of death, then those assets are protected and there will be no reimbursement from the state. But if they're not in a trust, then the state will come back and try to get reimbursed from the heirs of the decedent. The final difference is if a minor or legally incompetent adult wants to establish a first party special needs trust, they can't do it without the help of a parent, grandparent, or legal guardian. Otherwise, they have to go to a court and have the court establish it. So that becomes a challenge for a lot of people. A lot of people with special needs aren't mentally competent, and so they can't do it. So it really becomes important for a parent, grandparent, or legal guardian to establish it. But note the distinction, even though that parent, grandparent, or legal guardian is establishing it, it is not a third party special needs trust. It is a first party, and it's administered like a first party trust. And that will keep the court out of it. If the court has to establish it, then they're going to have to make sure the trust is exempt to allow for the public benefits and to make sure that there's no no creditor fraud or anything along those lines. So you really don't want the court getting involved. The last thing I want to talk to you about today is there are some specialized types of first party special needs trusts out there. The first one, and most special needs trusts are I don't want to say generic because every situation is the same. Is unique, but they have similar type of terms in them that makes them just a standard special needs trust. But some of them need some more specialized planning. And one of them that is called a Miller Trust. That's used in states where your public benefit is based on an income cap. And if you as a beneficiary are receiving more in income than the cap limit, then you can set up this special Miller Trust where part of your income goes to you, the amount that's allotted by the state, and then the remainder of that goes into your trust, your special needs trust. And so that may be something that may be necessary for some people. Another type of special needs trust, which is not just a first party, but it can be a first and third party together. It's called a pooled trust. And a pooled trust is established by a nonprofit or organization or charity to benefit multiple beneficiaries. So, maybe like Autism Speaks or somebody wants to set one up to benefit a bunch of individuals. So they set up this one special needs trust, and then Autism Speaks or whoever the nonprofit is, they administer the trust, they file all the taxes, they make the investment decisions, and they serve as the trustee of the trust. But even though the funds are all pooled in that one trust, each beneficiary has their own separate account. And that account can be either a first or a third party, or funded by a first or third party asset. Just like with any other special needs trust, though, they can be used for the same purposes as long as they are crafted carefully and follow all the formalities. Now, it is worth noting that although these pooled trusts sound great, you probably have never heard of them because a lot of states actually have penalties if the beneficiary of the special needs trust, the pooled special needs trust, is over age 65. So you don't see these all too often, but they are good in limited circumstances. Ultimately, I hope you guys understood everything and you learned something today. I believe we'll be doing a question and answer session at the end. I do want to give you a disclaimer though. If you have general questions about what I said, then feel free to ask those, in the questions and answers section down below. But if you have a question that's specific to your situation, keep that information confidential. Don't share it with everyone. Contact Lisa's office or myself or Yanko at QX Financial. And I know we will set up a free consultation. And I believe the rest of them will do the same.
Thank you, Phil. And I'd like to open it up for Q&A. So if anybody has any questions, like Phil said, please submit that through the Q&A feature. Yanko will be monitoring those to ask either Phil or I, or as they relate to financial questions, we'll let Yanko address those.
Exactly right. So while we wait for some questions to come in, if you guys have any, let me make a final comment on this because as financial professionals, we focus on the financial aspect of special needs planning. So Lisa, Phil has given you guys kind of like the legal framework of how to set this up. And again, if you have questions to your particular situation, then we can answer those individually. But the important part also, once you have this legal system set up, is how are we going to fund this trust? In other words, where is the money going to come from to pay all these benefits? So I'm going to give you some ideas on that today. But actually, we have a question here. So either I think it will be for Lisa, I believe. How far in advance can I set up my first party special needs trust for an anticipated inheritance?
So Phil, if you guys want to kind of tag team this one with an anticipated inheritance, if the individuals, presumably a parent, grandparent, loved one, are still alive and they've discussed leaving you that inheritance, I would always suggest having that person contact an estate planning attorney to set up a third-party special needs trust. But if you're interested in setting up a first-party special needs trust for maybe if your loved one has passed away and now there's money coming to you in a short time period, I'll defer to Phil to discuss more on the first-party special needs trust.
Absolutely. And even if your relative is alive, we have a lot of clients that come in and their parents are stubborn and they're old fashioned and they don't want to set up a trust. So if you have that situation, you may want to set one up yourself as well. But the answer is you can set it up as far in advance as you want. It's never too early. if you are receiving benefits, why not set it up? You never know what's going to happen, and you want to make sure that you don't lose those benefits later in life.
Awesome. Well, thank you guys. So I know I'm probably the last thing between you and the end of your day. So let me go through this information really quickly for you guys as to where we can help you as financial professionals. So the first thing that we do with our clients is to identify what is the need. How much money do we need to have to be able to, again, fund the needs of this special needs individual, right? As we were saying, some of them will qualify for government benefits. So how much will that be? And also, does that cover anything beyond food and shelter? Sometimes that's not the case. So what about if they need a car? What about if they need a computer or things like that? So the first step is to identify what those needs are going to be, right? And then we actually do an X-ray, so to speak, of your financial assets and figure out what are the assets best positioned to really fund the trust. I'm going to give you two examples today as the way most people do it. There's mostly two options. Some people will choose what we call a sinking fund, right? Which means we don't have all the money we need, but we're going to save every month, stocks, bonds, mutual funds, CDs, checking accounts, whatever. We're going to put money somewhere, and eventually we'll have enough to provide for the needs of the individual. And that's a good way to do it. Other people choose to just buy life insurance so that when I die, there is a bunch of money coming in for the benefit of the special needs individual, right? The challenge of the sinking fund is what happens if you die too soon, right? There may not be enough money there. And for the person that just buy life insurance, sometimes the issue is, well, if I'm just paying premiums, what if I need the money? What if I need to access that for my own retirement as a parent, if I'm doing like a third party special needs trust? So actually we can combine those two things. And so we can use something that we call permanent cash value life insurance, whereas you have the benefit on the life insurance until the day you die, but that insurance also generates dividends, interest, and gives you access to cash values. And there's a lot of tax benefits in doing that, which I won't talk about today, but we can talk about individually. So really, this idea of kind of combining two things addresses 5 points. And I see some questions coming in, so I will address those. So 5 things that this addresses. What about if I die too soon? Well, there's a sizable benefit that will be there to guarantee that the money will be received and used in the right way for the benefit of the beneficiary. What if I need money before I die? Well, you have access to the values of that life insurance policy while alive, so you can use it for whatever you need. What about if the market crashes? We can build guarantees into it so your money is not attached to the market. What about inflation? We can also make sure that the value of the policy keeps up and goes a little bit beyond inflation to make sure that if this happens 20, 30 years down the road, there is enough money there for the beneficiary. And lastly, what about taxes? If it's structured correctly, life insurance can be passed, or the death benefit of life insurance can be passed to the heirs without any capital gains or income tax or estate tax due. So that's my brief commercial. So let's get back to the question. So from Reina here, she says, I have a child with special needs and we've set up a special needs trust. At what point do you fund it? When we pass, what if there are other family members that want to leave the child something?
Lisa, you want to take that or you want me to?
Yeah, sure. So I'll go ahead and I'll start, and then Phil, if I missed something or if there's something specific to California that you want to address. So right now, if you have a special needs child and you've set up a special needs trust for their benefit, at what point do you fund it? This really depends on what kind of trust it is. It sounds like it's a third-party special needs trust, and it's going to depend on the terms of the trust. So for example, in the example I gave with Bill and Mary, their trust for the third party special needs wouldn't be funded until Bill and Mary's passing. There are other types of third party special needs trusts that can be funded during the beneficiary's life that can be used for their benefit. So it would really just depend on the type of trust and what the terms of it say. And if there are other family members that want to leave something to your child who is a special needs and wants to make sure that they don't get disqualified from any public assistance benefits or anything else like that, again, I hate to use the lawyer answer that it depends, but it really does, on how the trust is drafted, if other people can make contributions to it, and then also state specific laws. Some states prohibit other people from funding a third party special needs trust other than just the grantors. If this is something that you have more questions on or would like a trust review, depending on what state you're in, Phil's in California, I'm licensed in New Mexico and Arizona. You will receive a link to the questionnaire at the end. So if you want to discuss your plan in more detail, you can reach out to us and we'd be happy to review that for you.
And I think, you know, you had asked at what point do you fund it, Raina? You know, if it's through the inheritance, like Lisa just said, then when the parents pass away or whoever created the third party trust, that's when it gets funded, is when they pass away. But if it is a first party special needs trust, then that gets funded when the windfall or the money comes to the beneficiary. So if I win a lawsuit and the money's coming to me, well, when that money comes, the court funds it directly to the trust at that point. And if I don't have any money coming, then there's no need to fund it at that until then.
Excellent. We have one more question from Carol. If the parent has a trust, do they need to set up the special needs trust now or have instructions to establish it by a successor trustee? Also, what happens then to the trust when the individual with the special need passes away? Is the trust dissolved or will the assets need to be moved out?
You want to take the first part, Lisa? I'll take the second part.
Yeah, sure. So I would highly recommend that the parents set up the special needs trust as soon as possible. It's always better to do that within the revocable living trust, to set up that special needs third party special needs trust. I have seen it in the past where it's established by the successor trustee, where the trustor, so in my scenario, Bill and Mary, give instructions to the successor trustee to set up that special needs trust. They're very poorly written. They have very loose standards and they don't always align with state specific benefits. So, you know, a lot of the times we have to end up taking those to court for interpretation or for the court to bless it, to say, yes, this was actually a third party trust. Or I've even had a court force the distribution out and have that beneficiary then set up a first party special needs trust. And so it creates a lot of potential issues. It's always better to head those off at the beginning and have the parents set it up now, as opposed to providing instructions to a successor trustee.
Yeah, absolutely. And then what happens when the special needs individual passes away? Well, once again, it depends. If it is a third party, like I discussed earlier, then the party setting up that special needs trust can say what happens to the assets after the special needs beneficiary passes away. If it's a first party and you're in a state that requires the language to allow the state to recoup any medical assistance payments, then the state may get their cut at it before the heirs do. If there are heirs listed in the trust as backup beneficiaries, then the assets will go to those heirs. If there's not, then it will go through the normal inheritance procedure, which would be, you know, the kids and then the grandkids and the great grandkids of the person who passed away. If they don't have them, then up to the parents and the siblings, and it's a whole prescribed method of who inherits. And so typically it depends. The way that it's written, sometimes the trust will disappear and dissolve and the assets will go somewhere else. Other times it'll continue on for somebody else. It really depends on how it's written, and the choice is up to the person who wrote the trust.
Fantastic, guys. Well, thank you for those answers. I don't see any questions anymore in the chat. So I think we're probably done for today. I want to thank you, Lisa, Phil, for answering those questions and giving us that great explanation. I think that gives us the fundamentals to at least understand how these trusts work. Like Lisa said earlier, if you guys have any questions, if you want to learn more about this trust, or you have something that is specific to you, whether in the financial area of it or the legal aspect of it, please reach out to us. You'll get the information after the webinar. And, you know, again, thank you so much for your time and have a wonderful evening.
Thank you, everyone.
Hi, thank you, everyone. Appreciate it.
You guys take care. Have a good night.